Seth Berenzweig here with my colleague John Polk in the Washington, D.C. area, and we're here talking about one of the hot issues of what's happening here in our neck of the woods, and it's obviously being covered and impacting the whole country, the Senate impeachment trial. So, John, we're coming to the end of another week. We're in the question and answer phase. A lot's happened, a lot's been going on. Break it down for me. Where do you see how this is going and where it's headed?
Well, where the Senate should be going is where they should be starting, actually, is with the words of the Constitution. And I hope they're doing that. I'm not sure they are. But the Constitution itself only provides 4 grounds for removing the president from office. Mm-hmm. He has to be impeached for and convicted of treason, bribery, other high crimes, and misdemeanors. Now, what do those all have in common? They're all crimes. And if there's any slight ambiguity at all, it's in the word misdemeanor, which is commonly used to mean a crime.
Okay.
And it does have a secondary meaning. But there's a well-known canon of statutory construction called the associated words canon, which says that when you have several definite terms in a set, mm-hmm. and one term that might be slightly ambiguous, you determine the meaning of the ambiguous term by reference to the specific terms. Mm-hmm. So I think the only way you can sensibly read the impeachment clause is that the president must be convicted of a crime.
A statutory crime.
Well, it doesn't have to be statutory. It could be a common law crime, but
okay.
it has to be a crime.
Okay.
And I think that it would be the impeachment clause, the first impeachment clause, accusing the president of an abuse of power. That isn't a crime, and it's unconstitutionally ambiguous. I mean, what is a crime?
Mm-hmm. Alan Dershowitz, by the way, is suddenly feeling a good vibe coming from the studio because you're basically supporting, generally speaking, Professor Dershowitz and his position last night that it has to be something that's not contemplated as happened with the president here. We'll get a little bit more deeper into his comments in a moment, but I mean, historically, this is not the first time that a president of the United States has been impeached under an article specifically entitled abuse of power or abuse of his office. So this is not the first time that we're seeing this. This was something that has happened before. And one of the things, just to kind of respectfully push back, when the Constitution was written, there was no criminal code at the time, right? I mean, when they were talking about high crimes and misdemeanors, Adam Schiff's argument on this is that this is the highest level of an abuse of office, and that everything else that would fall underneath it, such as bribery, for example, could, as a prosecutor might say, could be a lesser and included crime. But I mean, when Professor Dershowitz argues last night that this is not impeachable, and that even if you're acting as a president in the mode of a quid pro quo, as long as he feels that it's in the best interest of the nation, it's still not a crime. How is that a standard that has any practical application here? Because some of the arguments that I'm hearing from the other side, I consider to be pretty unbelievable.
The phrase abuse of power is unconstitutionally vague. If the founders of the Constitution had intended to give Congress that power, the power to remove a president because in their subjective judgment he'd abused his power, they most certainly would have said so. It's impossible to believe they wouldn't have spelled it out, because one thing our Constitution does is that it clearly circumscribes and attempts to delineate the powers of the different branches of government. And if the founders had intended that the Congress could exercise that power just to remove a president because in their subjective judgment he'd abused his power, they would have said so.
But isn't the whole essence of the clause of a high crime and misdemeanor, isn't there some element of flexibility and fluidity in that? I mean, isn't one of the reasons why we have a living, breathing document as a Constitution is that you have a clause that can have a reasonable meaning that's being applied here? If a president is able to allegedly cheat his way forward into a re-election such that it could be an abuse of office, and if these things did occur as alleged, then how is that not a high crime and misdemeanor? It sounds like that this is kind of a technical
The
argument.
Constitution is not a living, breathing document that changes its meaning in some flexible way from generation to generation. It's a founding document.
Mm-hmm.
And I don't see how we can avoid the words of the impeachment clause. Those words mean something. And if Congress if the founders had intended to give Congress that type of power, I submit they would have done so.
Well, if Adam Schiff was in this room, one of the arguments that he would say, because I heard him make this argument, so I'm going to cite him as my source, to borrow a phrase from the congressman, he said that bribery would be essentially a lesser and included charge as to the higher, broader crime or the higher level offense, if you will, of an abuse of power. And that, in fact, the facts here are susceptible to bribery. I mean, really, I think that the facts could be explained as trying to extort a bribe. But if a president can't be removed for abuse of power in a situation like this, then for what could he be or she be removed?
Well, Adam Schiff's lesser included argument is flim-flam. They knew that they didn't have the elements and the facts to prove the elements of a bribery, and that's why they didn't impeach him. Why would they not have included an article of impeachment of bribery if they had the evidence?
Well,
and they didn't have the evidence.
Bribery was in the House report, though. I mean, that's not a foreign concept. I mean, bribery was a topic of the hearing. It's in the House report. He said this week that if they listed bribery explicitly as a lesser included, then the Democrats would be accused of having a duplicative count, because then they said, well, then it'd be defective for that reason. So obviously the Republicans are going to attack it one way or the other.
Oh, but that is absolute nonsense. If they had the evidence and the facts to prove bribery, which they don't have, right, given the facts of the case, there wasn't sufficient evidence for bribery or even extorting a bribe. How do you ever prove an extortion of a bribe when the person on the other side, President Zelensky, has said how many times he didn't feel any pressure? How do you prove it? They knew, Seth, they knew they couldn't prove it. These impeachment articles are a nakedly political impeachment. That's what it is.
Well, unfortunately, for better or for worse, this is a political process by nature of having it go into the Senate. But I guess you're referring to the UN side meeting that happened in front of the cameras, where our president was trying to have Zelensky be pressured to saying that he was not pressured. So that was kind of an interesting, ironic situation there.
Seth, he said it independently of that. He said it several times.
So,
I don't know how you get extortion and bribery in a situation like that. You can't get to it.
Give me a clean slate. Mm-hmm. A president, not necessarily Trump. The next president cheats, tries to allegedly cheat and abuse his or her office to secure an unfair advantage to take the next election. Alan Dershowitz said last night to the Senate chamber that if there is a quid pro quo by a president to be able to get an advantage in the next election, it's not removable if the president believes that it's in the best interests of the country, which to me is absolutely an unbelievable argument. I know that there may be a lot of people that have a lot of respect for the professor. I respect him as an intellect. I found it to be incredible that we're sitting in one of the most revered chambers really in the United States, no less Washington, and we're getting this kind of rationale. What's your opinion on that theory, and is there any scenario by which there is someone who could be cheating from the White House and they would be subject to removal under the Constitution?
What happened in 2016? There was an investigation of Trump's political campaign in 2016. It was participated in by Brennan, by Clapper, by Comey, and certainly with the knowledge of President Obama. An attempt to use the investigatory process to discredit Trump and his campaign. Wasn't that an abuse of power? Did anyone suggest impeaching Obama for it? Of course not. So why are we doing it here? Because the Democrats have a majority in the House, right, and they have been from day one, from the day after election, they've been trying to figure out a way to get rid of the president.
It's an inherently political process. I'm with you on a lot of this, and it's an inherently political process.
I disagree that it's an inherently political process. It has to be a process. The Senate.
It's inherently political. It has to be.
It has to be a process that adheres to and is faithful to the words of the Constitution.
Well,
and Hamilton in Federalist 65, that's one of the things he worried about.
Right.
He was worried that this would become a political process. It's as if he foresaw what the Democrats were going to do this year.
Hamilton's the new star. He wished that he had an agent today, because between Broadway and what's going on, being quoted in the Senate chamber and in the House, Alexander Hamilton is like so in for a guy from back then as a founding father. But I think that if you're talking about the intent of the Constitution and what's happening in the Senate chamber, I hear and respect about what you're saying, and there's a lot of different arguments and a lot of different interpretations, as you saw from the question and answers from the senators. But I will say this, I found it absolutely unbelievable that on the Senate floor, a constitutional attorney stood up in front of a microphone and said that it is not a removable offense for a president to take a quid pro quo to try to unfairly advance his personal interest to win an election if he believes that it's in the nation's personal interest, and that is not a removable offense. I just find that we're really in an unbelievable inflection point in our country. And if that's where we are with this argument, as Adam Schiff would say, we're lost.
Well,
you get the final word.
What you're saying assumes that there actually was a quid pro quo, and I don't find it in the memorandum of the phone call between Zelensky and Trump.
Well, there's a guy by the name of John Bolton that might have a thing or two to say about that. But as the president says, we'll see what happens. So we have to leave a little bit on the table so that we have something to talk about in the next week or so. We're going to have to end it there. But John, thanks for talking about it. A lot of activity happening in Washington over the next week or two, and we'll be here to cover it, and we'll be back and talk about the next steps.